What is up, guys? Truth and Transparency. How we doing? Friday. Oh, yeah. Again, Adnan Syed will be covered. His motion to vacate will be discussed. Yeah, all of this. Just a couple things. I think it's 21 pages, but again, welcome to the Transparency. What is up, Bumblebee? Got some more information for you guys. Gonna break things down. See what you guys think. But anyways, happy Friday. Again, Adnan Syed, state of Maryland, free man. And Maryland has 30 days if they want to recharge Adnan. So we'll give a couple seconds, couple minutes for people to get in chat. How's Bumblebee feeling today? Hey, you have a countdown now. Yeah, I mean, I've had the ability to do this, but, I mean, I can also put on some music in the background. I also changed my background. Let's check this out. Let's see. Well, I'll show you guys later, but how's your Friday been, Bumblebee? Again, cheers. Today's episode is sponsored BL. Looking fine, like a cheap wine. Cheap wine always looks so fine. Doesn't feel too good in the morning, but again, welcome. So what we're going to be talking about here is what you're seeing here is the actual motion to vacate Adnan's conviction. So it's like it never happened right now. I know yesterday we had talked about Jay Wilds and what did Jay Wilds get in return for his testimony. And I remember that I knew that it was a suspended sentence, and I knew that he just did some probation. I was correct in all of that. It was 5 years for an accessory after the fact. He was given 5 years suspended sentence and did 2 years probation for his testimony to put a man away for life plus 30. So let's talk about it. Let's talk about this. How is this possible? You know, this motion to vacate. When did this become a thing? And it became a thing in 2019. Maryland, passed a law that would allow this. So, in 2019, Maryland then had the ability to, a prosecutor or DA could go ahead and put in a motion to vacate a sentence against an inmate. And actually, Mosley, I went ahead and did some deep diving because I have nothing else to do with my life, but it took maybe 2 extra hours of not sleeping. But I wanted to deep dive Mosley because I thought it was very interesting. You know, what drove her to want to do this? Has this been something that's been happening? Is it election season? And I listened carefully then again to her speech that she gave, her press release. It was live. But yeah. Mosley, there's like 800 people due to these, again, I'm just going to go ahead and read it here, but 800 people she is looking to basically get out of prison. So, again, if I'm going to talk about it, I'm going to be educated about it. You know, I think whether or not I was going to talk about it or not, I wanted to know about it because I think it's amazing. But how did this happen? To me, that's what interests me, is how did this happen? Is it something that, other states are going to start doing? Things like that. So again, hello to chat, Rarity, Bumblebee, Morgan, BL. Again, if you guys want to talk about true crime, this is where you can find it. Would love to know your thoughts, opinions. If you feel like you want to come on panel, say something, or call in, let me know. Hot AM Radio. Yes, driving and listening. Good, because you're going to like this one. If you're definitely if you're driving, because you can learn. Okay, so check this out. I'm going to go ahead and do right here. Hold on 1 second, guys. BRB. All right, guys, welcome back. Yeah. Okay. Here we go. I'm going to go ahead and do this. Actually, I mean, you guys probably don't need to see my face, but, you know, if you guys want to see it, if it makes you, you know, want to hang out longer. All right, here we go. Motion to vacate. So, I'm going to actually start with the facts of the case first, and I want to have a certain order. Here we go. The facts of the case have been as followed. It's going to be actually really shrunken down for the point of this motion, but for the purposes of this motion, the most pertinent facts are as follows. The victim, 18-year-old Heyman Lee, was last seen at Woodlawn High on January 13th, 1999, around 2:15 to 2:30 p.m. Weeks later, on February 9th, 1999, her body was discovered buried in Lincoln Park. The cause of death was manual strangulation. The investigation turned to the victim's ex-boyfriend, Adnan Syed. The state's theory was that the relationship was an on-again, off-again relationship that began in 1998. Miss Lee started a new relationship, angering the defendant. Yes, son. Hold on 1 second.
I'm hungry.
What would you like, baby?
Something.
Oh my gosh, Mod Squad's in chat, love. Hi. Mod Squad, do you want to come on panel? Let me know. I always love a hot co-host. Fire. Well, Jexy, we're all going to be going out and grilling out and doing Red Rover, and Ghost in the Graveyard, so... Mod Squad. That boy is hungry as my boy. Yeah, they eat all day, every day. I mean, it's not like I don't feed them. I think everybody knows that, but every day, all day. Yes. All right, carrying on. I think all boys, when they're growing up, they just can eat. So again, Lee started. Again, this is their theory. This is the state's theory that Miss Lee started a new relationship, angering the defendant. The main pieces of evidence implicating the defendant was the testimony of the cooperating co-defendant, Jay Wilds, who testified basically to the following. Defendant said he was going to kill the victim. Defendant admitted to strangling the victim. Defendant showed Wilds the body in the trunk of the car. And Wilds helped defendant bury the body in Lincoln Park. Wilds also directed police to the victim's car on February 28th in the area of the 300 block of Edgewood Avenue in Baltimore City. So again, I think yesterday a couple people were asking where the car was. There you go, 300 block of Edgewood Avenue. That's one of your answers. The other main pieces of evidence came from the defendant's cell phone records. According to Wilds, the defendant lent him his cell phone and vehicle that day. The cell phone was in Wilds' possession at the time of the murder. Wilds and defendant were together at the time of the burial around 7 p.m. The state relied upon billing records showing the phone was connected on incoming calls to cell towers, placing defendant's phone in the vicinity of Lincoln Park around 7 p.m. The state's contention was Wilds' testimony, coupled with the cell phone records, tied the defendant to the victim's burial site in Lincoln Park. Here it is. This is answer number 2 from yesterday. Wilds pled guilty to accessory after the fact on September 7th, 1999. He testified against the defendant in that February trial in 2000. He was sentenced on July 6, 2000 to 5 years, all of those years suspended, with 2 years of probation. Now, so again, those are, in a nutshell, the what they consider in this motion the facts. I can list all of his favorites. I'm guessing food there. As far as the introduction, after a near year-long investigation by the state and defense, who was represented by Erica J. Sutter of the Office of the Public Defender, and the University of Baltimore's Innocence Project, the parties have uncovered Brady violations and new information, all concerning the possible involvement of 2 alternative suspects. Additionally, the parties have identified significant reliability issues regarding the most critical pieces of evidence at trial. Investigative efforts are ongoing. The state will continue to utilize all available resources to investigate this case and bring a suspect or suspects to justice. To be clear, the state is not asserting at this time that the defendant is innocent. However, for all of the reasons set forth below, the state no longer has confidence in the integrity of the conviction. And those were key words that Corey Woods used. Those words right there, the integrity of the conviction, of the judicial process, the integrity of it. That's the key words that Corey Woods used at Sheldon Jeter Jr.'s hearing that I was just at. The state further contends that it is in the interest of justice and fairness that these convictions be vacated and that the defendant, at a minimum, be afforded a new trial at this time. The defense is aware that should this motion be granted, the state's decision to proceed with a new trial or ultimately enter the charges upon the result of the ongoing investigation efforts, the state will be requesting the defendant be released on his own recognizance, but pending the investigation should be that this court wants to move forward. And basically they have 30 days to do that. So it's Maryland's Rule 4-333. Within 30 days after the court enters an order vacating a judgment of conviction or probation before judgment as to any court, the state's attorney shall either enter null or vacate. So it has 30 days. And so now I think we're down to like 25 days. When did this happen? On Monday? Now, the DNA testing. So really quick, I want to go right back up here. This was a lot of the DNA testing was the big part of in 2019, then 2019, then 2020, 2021. It's been around all of this DNA that either A, was already tested, but it wasn't. I mean, this is back in 1999. So when you're talking about how, advanced we are today versus then, and then also stuff that was never tested. So, again, I'm going to look here at chat. I haven't looked, so I want to say hi to some people. Integrity is key. Yes. Mod Squad, you like that background drop? The fall leaves of Aliquippa. Chef's kiss. Henforcer. Hi, Mod Squad. And Bumblebee. I've been meaning to follow one of your cases end to end. I'm interested in what you do. Well, the case that you want to follow is Sunset Secrets. That's what I do. So go check out the first episode of Sunset Secrets. It's season 3, and it just kicked off 2 weeks ago. They usually drop on Sundays. I have back-to-back episodes dropping this week, and then I usually do a follow-up after the episode drops, usually 2 days afterwards. That way people can see it and then participate in the follow-up. So that's definitely what you want to do, and you're going to love what I do. So here we go. The status of the DNA testing. The reason I love briefs, motions, any type of supportive material when you oral argue, breaks it on down like a motherfucker. Okay, here we go. In 2018. Remember, he was arrested in 1999, convicted in 2000 after there was a mistrial. Like within like a week, then they declared a mistrial, then another trial started just like a month later. So in 2018, the Baltimore City Police Lab tested various items for DNA through an agreement between the Office of the Attorney General and the defendant's previous counsel, who I've actually spoke with. That would be Colin. The testing yielded mostly inconclusive DNA results or no DNA results. On March 10th, 2022, the state and defense filed a joint petition for post-conviction DNA testing of the victim's clothing. Specifically, the parties sought to have an independent lab test the clothing for touch DNA, which procedures were unavailable at the time of the trial. The items being tested in 2022 were not previously tested in 2018, with the exception of the victim's fingernails. After consultation with DNA experts, the parties tested the items believed to be, or to most likely yield results for touch DNA. Those items were as followed: fingernails, fingernail clippers, pubic hairs, underwear, bra, and shirt. the rape kit was also tested for DNA. Trace level male DNA was detected on the victim's right fingernail swabs, the right fingernail clippers swabs, and the victim's shirt swabs. The swabs from the right fingernail and shirt were then analyzed genotyping kit that targets male Y chromosome, STR-DNA. However, no useful typing results were obtained from this analysis. Another shirt swab and the right hand fingernail clippers were not analyzed because it was determined the amount of male DNA was so minimal it would not likely produce any results. Only female DNA was recovered from the following: pubic hairs, left hand fingernail swab, left hand fingernail clippers, the left hand fingernail clippers swabs, anal swabs, vaginal swabs, bra swabs, and underwear swabs. The remaining items are currently being reviewed for further testing. Now, I went ahead and I actually pay attention to the notes here. I'm going to look at chat. You guys have any questions? What is up, Jessica? Anyone looking to get in touch with Lana can do so by emailing Lana at Fight for a Family. Thank you, Mod Squad. Also, anybody that wants to join Fight for a Family, Mod Squad's got you covered right there. You can do a one-time donation, or you can just flat out be a fucking member and be sweet. And it's only $10 a month. It's a reoccurring $10 a month payment. It's all through the nonprofit website, and it's a tax write-off. Let's see what else we got going on. Okay. So, something that I thought was interesting here is the female presence of this DNA. If you guys have been following along, anything that I've been talking about to do with this case, which was yesterday and then a couple months back, to get everybody acquainted because I knew big things were happening in this case. You can get familiar with the case by listening to the Serial podcast. If you really want to know everything there is about this case, then you want to go to the Disclosed podcast, which is by a family friend of Adnan. Also, HBO did a 4-episode documentary. That's my advice. I'll make sure to link that. I'm going to be revamping my whole channel this weekend. So I'm going to be like tech savvy, which I freaking hate tech stuff. I hate it. But hey, you got to get with the times, Oriani. Let's pick it up. So I was really interested in this presence of, female DNA. Do you guys remember the JonBenet Ramsey case? Okay. And everybody was always hung up on the DNA on her panties and, oh my God, this DNA, oh my God, it's unidentified. But then when, I think it was ABC that did the special, they had a very good explanation for that DNA on the underwear. It was brand new underwear that she had gotten from Christmas. Okay. And like a bunch of little kids do, and especially around Christmas time, parents are a lot, lenient because, oh my God, I want to play with this or I want to wear this. What was no different? So the underwear that JonBenet Ramsey had put on was literally just received, just open, and it could have been the DNA from whoever packaged the brand new underwear that she had opened for Christmas. So I just want everybody to keep that in the back of their minds. I thought that they did a great job with that JonBenet Ramsey case special. If you haven't seen that, I recommend that. So going back to this, though, I was interested when they were talking about female, this female DNA. Which we're going to come to here in just a second. I want to continue reading for a little bit more, and then we'll be right back to it. Okay, so in 2018, the Baltimore Police Department lab tested, I think it was like 13 or 14, 12, okay. They tested the following: left fingernail clippings, right fingernail clippings, swab from bottle cap located at Lincoln Park, swab from mouth of bottle located at Lincoln Park, swab from white metal necklace. Number 6 is the swab from yellow metal necklace. 7 was the blood sample from back of shirt. And I thought that was interesting, the blood sample. There was blood on the back of what shirt? From back of shirt. Was this shirt just found in Lincoln Park? Was it her shirt? Was it there? Number 8, blood sample from back of shirt. Number 2, blood sample from back of shirt. Number 3. Number 10 was a swab from a condom wrapper found in Lincoln Park. Number 11, swabs from longer wire found at burial site. And number 12, swabs from shorter wire found at burial site. Again, and then they have these exhibits, 2018, the DNA test results. Exhibit number 2, again, this is all stuff from 2018. Exhibit number 2 is the joint petition for post-conviction DNA testing. And that was with the big to-do that happened back in March when they said that they were going to be testing this stuff. Forensics, the crime lab provided the latest results in a report dated August 18th, 2022. Again, that was from the March testing. I'm sorry, that was from the 2018 testing, and then they also did the March, so they had the testing from 2018, and they also had the testing from March of 2022. Since the investigation is ongoing, the state will not disclose the report at this time. However, the conclusions of the last round of testing have been fully disclosed above. Right here. That means this. Okay? So they had 2018 testing, and they did 2022 testing. Now, we just read the facts of the case. And now we're going to talk about, thank you, Vicky, appreciate that very much so. We're going to talk about the procedure. How is Adnan a free man? Okay, how is he a free man? How can he stay a free man? What's going to happen? And this all interests me. I'm not going to sugarcoat it. All of this interests me because of Jamie Brown, because of Sheldon Jeter Jr., because of the Rachel Del Tondo case, which that's where I'm at, as well as Davon Cox. And you guys are going to hear for the first time this weekend from the new case that I'm taking on that will be the season 4 of Sunset Secrets. And I'll get into that a little bit later, but obviously I don't do things that I don't think that I would never take something on that I didn't think that it was merited. If I believed that somebody was guilty and I believe that the evidence was there to, hey, they're where they need to be, so be it. But this case, Adnan Syed has always interested me from back in 2000. I knew about it growing up. I was like the same age as they were. I was a junior when he was a senior. Then obviously the love of the thought of crowdsourcing with Bob Ruff, what Serial did. But this case, just like maybe like 3 other ones that have, the McStay case, this case, OJ, I've done JonBenet, and then Natalie's, but this case I always felt was, if Adnan Syed was not, if he was white with blue eyes and just an all-American household name, he wouldn't be in prison. So the racial injustices have always been something that catch my eye. And I don't know if maybe it's because I was an athlete, and because of me being an athlete, I was always in diverse situations in terms of teammates. I've always had teammates that are white, black, mixed, and you name it. My teammates grew up, poor, wealthy, middle class. But at the end of the day, when you're like out on that court with people, like all of that, just none of that's even like in somebody's mind. It's just your talent is your talent, and that's all that we ever saw. So, but when we were off that court, I saw firsthand certain things, and I was always the first to, step up or say something. And so I don't know if maybe my bringing up has something to do with why I'm so passionate about making sure that the injustice when it comes to people that aren't white. So, but yeah, Adnan Syed had been in prison for 23 years. But how did he get there? What has happened since he's been here? This is what the procedural history is about. So let's talk about it. On February 25th, 2000, that was literally just a couple months before I graduated high school, a jury found Adnan guilty of the following offenses: first-degree murder, kidnapping, robbery, and false imprisonment. Again, Judge Heard imposed a total sentence of life plus 30 years. I think it's actually awesome when they went ahead and cited. So boom, right there, those footers right there will take you right to the Court of Appeals and the decisions. Again, that was in 2000. Then on May 28th, 2010, defendant filed a petition for post-conviction relief, petition number, which he supplemented on June 27, 2010. In that petition, defendant raised 9 allegations of ineffective assistance of counsel. Sentencing and appellate counsel. So, I'm sorry, both the trial, the sentencing, and the appellate counsel. 9 allegations. The post-conviction court issued an order and a memorandum, and on December 30th, 2013, denying all claims. Now take a look at this. 2010, he puts it in. He supplements it basically like a month later. The decision doesn't really come back for like 2.5 years. Okay? So this is what I've been talking about. If Sheldon gets into that point that this doesn't get overturned and this stuff can't start happening now, when you get into the post-conviction phases of our justice system, the chances of you getting out are very, very low. But more importantly, it's a very long process. Defendant filed an application for leave to appeal, specifically raising the issue of trial counsel's failure to interview or investigate Asia McClain as a potential alibi witness and failure to pursue a plea deal. After noting this application, defendant supplemented his application and requested that the Court of Special Appeals remand the case for the post-conviction court to consider an affidavit from Ms. McClain. This was a big part of the Serial podcast in 2014. Now, just because the Serial podcast came out in 2014, you guys, a lot of work goes into stuff like before that. Rabia was on and fighting for Adnan in 2000. She has been fighting next to that man for 23 years. 23 years. The request was granted on May 18th, 2015. That would have been a year after Serial podcast. So when you want to know what I do and why I think what I do, and people that want to be involved with what I do, this is going to be Sheldon Jeter Jr.'s story. Nowhere near the amount of years. It's going to be way less than that. But this is going to be also Jamie Brown's story. Again, the request was granted, and on May 18, 2015, the Court of Special Appeals issued a limited remand in which it would afford defendant, quote-unquote, the opportunity to file such a request to reopen the post-conviction proceedings in the circuit court. Because once you exhaust all of your options, you can't do it anymore. You get one shot at ineffective assistance of counsel. But he was granted from the Court of Special Appeals this opportunity in 2015. Upon remand, defendant filed a request for the circuit court to consider a new and independent basis for his claim of ineffective assistance of counsel, as well as purported Brady violation. This is when Colin was his attorney, by the way. Amazing human. Concerning the cell tower location evidence, the post-conviction court granted the request to reopen his post-conviction proceedings to review both on June 30th, 2016, so a year then later. On June 30th, 2016, the post-conviction court denied relief on the issue of counsel's failure to investigate Miss McLean as an alibi witness. Regarding trial counsel's failure to challenge the cell tower location evidence, the post-conviction court reasoned that the trial counsel's failure to challenge the cell tower information was in fact ineffective, and that this was a prejudice to the defendant. As a result, the post-conviction court vacated the convictions and granted defendant a new trial. Adnan Syed was granted a new trial, and his convictions were vacated on June 30th, 2016, only for the state to appeal. And on March 29th, 2018, so they appealed that basically ruling, and they kept him in prison during this appeal. The state appealed it, and on March 29th, 2018, the Court of Special Appeals held that the failure of trial counsel to call Miss McLean as an alibi witness warranted a new trial. However, the court reversed the post-conviction court's holding on the cell phone tower evidence on the basis that the issue was not properly raised in the first post-conviction. Therefore, it was waived. I'm going to come back over to audience here. What do you guys think? Anything? Let's see. Great point there, Mod Squad. Like Jamie Brown, Adnan has always maintained his innocence and fought the whole time. 100%. The difference between, Adnan and Jamie Brown is Adnan had one of the best advocates in Rabia. And she went out and got a hell of a team in the way that she advocated, and that's going to be something I'm going to be talking about this weekend, and something that exactly what Fight for Our Family is all about, and was supposed to be about, and will be about. So, a great point to make there, Mod Squad, that yes, he's always maintained his innocence. So, moving on. Again, saying hello to Vicky, Ellen, anybody new that just joined us. Now, on March 8th, 2019, the Court of Appeals reversed the Courts of Special Appeals and held that, Ms. McLean's testimony did not warrant a new trial. The court, however, agreed with the Court of Special Appeals that the cell phone tower issue was waived. Now, so here, guys, think about this. Think about being told that June 30th, 2016, as a result, the post-conviction court vacated the convictions and granted defendant a new trial, only to then have the state appeal that, win the appeal, and that's kind of where I'm hung up today, as to like, why would Maryland do that to him? But we're going to get into all that, and it all has to do with money and election season. Defendant timely here we go. Legal requirements. So in order to use the state's motion to vacate, these are the legal requirements to be able to even do that. In 2019, the Maryland legislature passed HB 874 and SB 0676 to allow the state to file a motion to vacate a conviction. This bill went into effect on October 1st of 2019. The immediate effect of the bill allowed the state to vacate convictions in which the conviction relied heavily on testimony from a member of the corrupt gun trace task force. This is why this was ever implemented. It had to do with the corrupt gun trace task force. The statute also allows broad applications to any conviction in which new evidence has called into question the integrity of the conviction, or there has been newly discovered evidence that creates a substantial or significant probability the result would have been different. The most recent, this office filed to motion to vacate in the case of State versus Paul Madison, in which the defendant was convicted of second-degree murder. After a re-review of the case, the state filed a motion to vacate on the basis that, and they list 5. The defendant's conviction was based on the uncorroborated testimony of a witness who was also a jailhouse informant who was promised benefits for an unrelated charge. Number 2, the informant testified that she did not receive benefit, which turned out to be untrue. Number 3, Brady violations discovered in the state's trial file. Number 4, 2 alternative suspects were developed that were not disclosed to the defense. And number 5, a new witness who advised the state of new evidence regarding the details of the murder. The state asserted in the motion that it, quote unquote, it no longer had confidence in the integrity of the conviction and asserts that the interest of justice and fairness justify vacating the conviction. And then it was, this is when it was used here in December 21st, 2021. The Honorable Court granted that motion, and Mr. Madison was released from being incarcerated. Again, something that I think is great is you have all these little footers here. And when I was looking at this, right here, number 9, Baltimore Sun, State's Attorney Mosby will ask courts to toss nearly 800 cases tainted by rogue mods with those wrenches like Melissa Jade. No, I'm just kidding. 800 cases tainted by rogue gun trace task force cops. So, of course, I was like, 800 cases. Well, guys, that's Beaver County. This is Beaver County. This is what Pennsylvania needs, because this is what Beaver County has done. Darn rogue mods, man. What are we gonna do about them? Again, Hot Ham review. Hello, Hot Ham. She is so unpopular in Baltimore. I think it probably has something to do with, I was told that she ran an unbought campaign. This weekend I'll be talking about Mosby a little bit more. Mosby. I think it's so easy to say Mosley. But moving on. You can catch, there was actually an episode on, right here, Oxygen True Crime. Judge vacates sentence for Baltimore man. Okay. We're going to come back to what the legal standard to vacate a judgment of conviction. We're going to come back to that. Actually, it's fine. Well, I'll say it now. I was going to go to a different one first, but the legal standard to vacate a judgment of a conviction, the state can move to vacate a conviction pursuant to CRIM 8-301.1 on the ground that either 1A, which is there is newly discovered evidence that that 1 could not have been discovered by due diligence in the time to move for a new trial under Maryland rule. See, this is what I'm trying to figure out how for Jamie Brown with the new evidence that I've discovered, because you can get, you can always put in a motion with new evidence. It's never going to change, in anybody's situation. So with the Jamie Brown case, I have come across a bunch of new evidence. And you basically want to put as much as you can, beef up a good motion with, if you have multiple, you have multiple. And that's going to center around everybody that was the quote unquote, the witnesses about the tow truck coming there, and the 3 witnesses with, Gordon and Tackett and all that crap. So, number 2, creates a substantial or significant probability that the result would have been different. In this situation and in Jamie Brown's situation, those people that walked down and knocked on the door and said that they saw Naim, and that it was at 8 o'clock, and that he was basically, that they're trying to say he was alive at 8. Had that never been there, okay, and those witnesses had never been there, then do I think that Jamie Brown's case would be different? Absolutely. Because you're putting him alive past 8 o'clock, when I believe that that's not true. So, the state's attorney received new information after the entry of probation before judgment or judgment of conviction that calls into question the integrity of the conviction. And number 2, the interest of justice and fairness justifies vacating the probation before judgment or conviction. Notifications to defendant, request for hearing, and then here we go. This is what I was just going to go to, but now this has to do with, this is Adnan's case right here. Number 6, 2021 to 2022 investigation. 2 suspects have been developed. The parties have developed evidence regarding the possible involvement of 2 alternative suspects. References to these 2 suspects will be mentioned throughout this motion as one of these suspects. The 2 suspects may be involved individually or may be involved together. These suspects were known persons at the time of the investigation of the case and not properly ruled out as set forth below. In the state's reinvestigation of this matter, new information was learned about these individuals that suggest motive and or propensity to commit this crime. However, in order to protect the integrity of the ongoing investigation, the names of the suspects, which suspect in particular, and the specific details of the information obtained will not be provided at this time. Now I'm going to give you guys a little clue. I'm going to give you guys a little sugar, sprinkles, whatever you want to call it. But I believe that those 2 people that they're referring to are one of the gentlemen, I believe, is dead. Moore, and the other one is the gentleman who found her body. They're referring to him in serial as Mr. S. And his name is Alonzo Sellers, and they say it in the HBO documentary. So no, I'm not doxing anybody. I'm just being thorough and efficient to my crowd. Now, here we go. Now, the reason I'm giving you those two, do I believe that Don should be added? Yes, but my thought is that either A, they're wanting people to think that it's these two and leaving that alone so that they can, you know, like I said, what they're basically saying right here, or whatever evidence that they have clearly, especially, you know, strongly points to the two individuals that I just said, mainly with probably DNA. I think the people who did it probably know they are suspects. Well, like I said, one of the men, he died in 2008 in prison while incarcerated. But it was his DNA that got into the system, okay? Because remember, when anything was tested in 1999, he wasn't in the system more. And I did a little information about him, you know, yesterday. I think it was yesterday. All my days run together. But more has since passed, okay? But there was a cold case, and they said in February of 2020, they closed it because they put her stuff back into they ran stuff again in a cold case out of North Myrtle Beach. And they were able to link more to that death. So, especially. People keep mentioning Jay. No, it's definitely not Jay. It's 100% not Jay. I'm with Rabia on that all day. All they used Jay for is you're going to say this, or, you know, we're putting this on you. The police, the detectives used Jay. That was all. So, moving on. A Brady violation. It was reported to the state that one of the suspects had threatened to kill the victim and provided motives for the threat. Now that interests me. The state located a document in the state's trial file which provided detail about one of the suspects. A person provided information to the state that one of the suspects had a motive to kill the victim. And that suspect had threatened to kill the victim in the presence of another individual. The suspect said that he would make her, Miss Lee, disappear. He would kill her. Now, if you actually listened, you guys are gonna believe this. If you've actually followed this case like crazy with Serial, but more importantly with like the Bob Ruff stuff and then the undisclosed stuff, that's a huge indication of who they're referring to. Now, that was Dawn, if my memory serves me correct. And that came from, God, what was her name? It'll come to me in a second. But, who could have possibly overheard this? When did this person come forward? Her vehicle was found at the 300 block of Edgewood. 300 block of Edgewood Avenue in Baltimore City. That's where her... So, well, her vehicle was supposedly found behind the house apartment of a family member of one of these suspects. They don't say which one of them. Yeah. And this is actually something that I touched base on yesterday, which was talking about the whole, like, this was a crime of... Was this a crime of opportunity, or was this something that was planned? Because Hay was very scheduled, meaning like right when she was done with school, she had to go pick up her cousin, then take him this, then go to this and go to that. And so when did anybody, have this opportunity? Who did she ever come across in that short amount of time that this, happened? Again, I'm going to be breaking down all of that in more detail this weekend. But absolutely, BL, her vehicle was obviously not where her body was. And if Adnan had his car, which Jay Wilds had, if you have your car, but then there's Hayes' car, okay, how are you doing this all with just one person? If in fact you have your own car, so let's say that someone came across Heyman Lee and they have their own car, what do you get? You get into her car? Well, why would Hay ever let a complete stranger into her car? How does that happen? What was Hay doing? Did she go somewhere that, this is during the middle of the day, between 2:15 and 2:30? She doesn't make it to hit the cousin that she had to pick up. That's why they're able to narrow down this window. And this is more stuff that I'm going to talk about this weekend, about this time frame. Again, this is called a Brady violation. So what that means, Brady violation, it was reported to the state that one of the suspects had threatened to kill the victim and provided motives for that threat. The state located a document in the state's trial file, okay, which provided details about one of the suspects. A person provided information to the state that one of the suspects had a motive to kill the victim. Now, Moore, that's the man that had, has since passed, he was released from prison 10 days prior to Heyman Lee, going missing, because I like to say missing, because that's what happened on on January 9th. She went missing. And then, because it wasn't until her body was found, and then obviously you're going to look at the autopsy, and they're going to go ahead and give you an opinion on when they think that her death was. But she goes missing on January 9th. And then it was it February 9th that she was found? She was missing on January 13th, something like that. It was right around a month. Yeah, the timing is very, very bizarre. Time is very bizarre because it's like I said, right after school allegedly, and because she had to be somewhere else, and someone was relying on she had to pick up her little cousin. That was something that she did religiously. So obviously, if she's not there to pick up the little cousin, then that's where the state was like, okay, this is a really small window. Here we go. But here we go. The state also located a separate document in the state's trial file in which a different person relayed information that can be viewed as a motive for that same suspect to harm the victim. This information about the threat and motives to harm could have provided a basis for the defense to present and or to bolster a plausibility or the plausible alternative theory of the case at trial. Due to the ongoing investigation, further details of this information will not be provided at this time. Now think about this. How could somebody that does not know Heyman Lee from Adam, never met her, how could they have motive to kill her versus like a serial killer? A serial killer doesn't have motive to do something. They're a serial killer that has usually a pattern, has it's an opportunity normally for a serial killer. But with this motion, what it's leading me to believe, based on the way that's written, the words, is you're basically telling me that this information about the threat and motives to harm, that there was a motive, well, you have to know somebody in order to have a motive. Or at least somebody has to know somebody, the person that would have been murdered, to have motive. There has to be, if there's motive, you usually know the person. Does that make sense? What do you guys feel about that? Do you think that a stranger could have motive? Yeah, if they were paid, in my opinion, to be like a hit person. Sure, they have motive because their motive to kill was for money. But let's say that Hay was pregnant. Well, you're not having my baby. You won't have an abortion. You're pregnant. So therefore, whoever maybe got her pregnant doesn't want to be having a baby. And therefore, they kill her. Something like that. But what type of motive would a man that just got out of prison, who does not know Haman Lee from Adam, and who is just basically a repeat offender, but to make a comment to somebody, so a motive to kill her because what I was planning, I told somebody I was going to rape her, and then I'm going to have no choice but to kill her because I raped her. Now my question's all going to come in when it said, well, what's the motive for the Baltimore detectives and the Baltimore police? Why not just go get the person that did it? What was their motive to frame Adnan? So again, we'll read this one more time because I think it's very important. The state located a document in the state's trial file which provided details about one of the suspects. A person provided information to the state that one of the suspects had a motive to kill the victim, and that the suspect had threatened to kill the victim in the presence of another individual. So whoever this individual was, that was what they told the police, the detectives. This individual would have been the person to write this and to say this. The suspect said that, quote unquote, he would make her, Miss Lee, disappear. He would kill her. And I believe, if my memory serves me correct, I mean, you have to think about this was 2014, 2015 when I deep dived the shit out of this case. I believe that came from one of Haman Lee's friends. And it was one of the only friends that ever met Don. Now, I may be wrong, but that's what I remember from hearing a little bit of this than just the past 2 days. The state also located a separate document, so document number 2 in the state's trial file, in which a different person relayed information that can be viewed as a motive for that same suspect to harm the victim. So now we're talking about 2 people. Not 1, but 2. Saying about the same suspect. This information about the threat and motives to harm could have provided a basis for the defense to present and or bolster a plausible alternative theory of the case at trial. This information was not contained in the defense's file, nor was it included in any of the various discovery pleadings the state produced each time it disclosed new information to the defense. That's her. Yep. Debbie. I knew it. I knew it would come to me. Hot ham. Hot ham radio. Yeah. Hot ham. That's it. Debbie. Yep. Who also said he hit on her. Yes, that's her. That is Debbie. Yep. But see, this was never disclosed, to the defense, but I'm telling you, in that, either it was serial. I'm telling you, I think it was serial, where it touched on a little bit, but I think that undisclosed hit it hard, and I believe that Bob Ruff hit it hard too. So, I'm gonna be back a little bit later. We're gonna go hang out and do what we do Friday night, yum. But I'm gonna be picking up right here after the Brady Bunch here. because I have a lot that I want to say about this part of this Brady. Because there's Brady violations left and right, if you want my opinion, in the Jamie Brown case, but what do I know? So yeah, we'll be picking up here right on the 8th page of this motion. It's 22 pages, but this is the stuff that, you know, you can do all the work in the world to do what I've done for like Sheldon or Jamie and find stuff, but you have to be able to take what you've, you know, uncovered and get it into the right hands so that they can, you know, do what's necessary to submit it to the courts and in a way that it's accepted, timely, and when it's supposed to be, you know, admitted based on whatever the, you know, if it's ineffective counsel, there's certain times for that. New evidence can, you know, go in whenever, but this Brady stuff, I mean, that's why I think it's crazy that any department would let you shred notes that you are handwritten, or your handwritten notes should never, they should have to be there going. Why every department now doesn't have body cams, why, you know, you talk to somebody, why isn't it just recorded as well? I mean, it's just, it's 2022 technology, let's go. Like, so yay, so excited you're explaining this new stuff. You're damn right I'm going to explain it. So come back and join me tonight. It'll probably kick off around like 9:30, 10 o'clock. But this motion, this is what people should be talking about and showing out there, because I believe that there's going to be a trial here regardless. I do believe that they plan on bringing, for as quick as this all happened, I believe it's just going to be as quick to arrest this person and to pursue obviously justice for Haman Lee. So again, thanks again there, Vicky, for that super chat. Thanks again for listening in chat. Come back and join this evening as the remainder of the motion will be broken down. Until then, be kind and always rewind. I think that Blockbuster should come back out. I miss Blockbuster. Friday nights, you go to eat, and then you go to Blockbuster and you walk around for like an hour picking out what movie you're going to watch, only to get home and fall asleep because you took like an hour or two at Blockbuster. So, alright, until then, guys, see you soon.
This is a preview file. For example, use only.
Sitting up or down, it doesn't change the oath, but raise that right hand. Under the penalty of perjury, do you swear to tell the truth, the whole truth, and nothing but the truth? All right, go ahead and have a seat.
This is a preview file. For example, use only.
the only credible witness here today.
For example, use only.
And frankly, is the only credible witness here today regarding her level of emotional distress. I find her testimony at the temporary orders hearing credible, and the testimony at the permanent orders hearing credible.
This is a preview file. For example, use only.